Be ready. Start. Legally, there is a distinction between failure to sign and verify the original copy of the election petition filed in the court and failure to attest the copy served on the respondent to be a true copy of the election petition. While the latter failure falls within the scope of Section 81(3), the earlier failure falls under subsection 1(c) and subsection 2 of Section 83. While the failure to comply with the requirements of Section 81 obligates the High Court to dismiss the election petition, the failure to comply with the requirements of Section 83 is not expressly declared to be fatal to the election petition. In view of the above, and having regard to the decisions, this court is of the opinion that in the present instance, the election petitioner had signed on the copies and therefore complied with the standard prescribed under Section 81(3). Similarly, the fact that the registrar of this court had initially notified some deficiencies which were cured, after which the matter was placed before the court which took cognizance of the petition, would mean that the election petition was absolved of any fault. There is no doubt that the election petition, as originally presented, was within the time prescribed by law. Moreover, this court cannot inquire into the question as to whether, and if so, to what extent the copies furnished to the second respondent were not compliant with Section 81(3) of the Act, that would amount to mini trial, a procedure unknown to the Act and in fact contrary to its objective. While public interest lies in ensuring that suits or causes which are plainly barred by law ought to be summarily rejected, equally the court should not be overzealous in the enforcement of provisions which are procedural, though aimed at expeditious trial, require substantial compliance. Both the pleading as well as the finding of the High Court are as vague as the vagueness could be. Exposition of law without first identifying the relevant facts in issue, in my opinion, does not promote the cause of justice. The appeal, insofar as the first issue identified by us in para 5 of the judgment, is required to be allowed and remanded to the High Court for an appropriate consideration of the objections raised by the appellant herein in accordance with law. A reading of the above paragraphs leaves us with the impression that the emphasis of the paragraphs is on the behalf of the appellant, that the election petition is a proxy litigation undertaken by the election petitioner on behalf of the unsuccessful BJP candidate. It is only in the last sub-paragraph extracted above a cryptic legal objection is raised that, in view of the fact that Annexure 1 of the election petition not only contains allegations of commission of corrupt practice by the appellant herein, but also by Vijay Goyal, BJP candidate. In view of the requirement of Section 82(b) of the Act, Vijay Goyal must also have been made a respondent to the election petition, and failure to so implead is fatal to the election petition. On the other hand, learned senior counsel Shri Ranjit Kumar, appearing for the respondent election petitioner, argued that the proposition of law settled by this court that an annexure or schedule to the election petition becomes an integral part of the election petition only in certain circumstances, but it is also recognized by this court that in certain other circumstances, annexures are only evidence of the allegation contained in the election petition, but not an integral part of the pleading of the election petition. Shri Ranjit Kumar submitted that the purpose of the election petition with reference to the Annexure 1 is only to derive support to his allegation of the commission of corrupt practice by the appellant herein by demonstrating that such allegation against the appellant is not only made by the election petitioner but also by others during the course of the election. It is neither the intention of the election petitioner to make any allegation of corrupt practice nor seek any relief against Vijay Goyal. Therefore, the election petitioner is not legally obliged to implead Vijay Goyal as a party respondent to the election petition. If the complaint made by the Youth for Equality to the Election Commission of India contains allegations of commission of corrupt practice not only by the appellant herein but also by some other candidate at the election, can such allegations against the candidate can be sustained legally or not? Thank you.